Welcome back to week 2 of the Constitutional Studies course. First, thank all of you for enrolling. I'm Sudhir Krishnaswamy and I'm from the National Law School. I'm sorry that I missed the first week with you, and I believe you've already got started. I want to begin this session with a quick recap of where we were last week and then take things from there. In week 1, we focused on 4 different questions. The first was, do democratic societies need a constitution? We asked. Do we need a constitution at all? Why don't we just leave all political societies to make all decisions by majority vote, and that's that? Is there any good reason why a democratic society needs a constitution? To that, we worked around to a conclusion that all democratic societies do need a constitution. We answer that with an emphatic yes. And we answer that the yes is based on some independent, different reasons which deserve some closer attention. First, even if we were to organize a small meeting in a room, let's assume a student meeting around a debating club, it would work better and sometimes may only work at all if we had some common rules for coordination. So we might say that X or Y person would be nominated as a judge, and participants would get a certain amount of time, and who would go first and who would speak second, and so on. These are simple coordination problems, but as social groups get larger and larger, coordination problems can become very significant. A constitution, even in a democratic society, even if it did nothing else, must help resolve these basic coordination problems that are endemic. They're there in all societies, even societies that are relatively homogeneous and relatively may share a common history and culture. The second reason that we explored at some length last week was that societies may not be all of these things. They may not be homogeneous. They may not share a common culture or a common history. And they might have deep disagreements about big ideas, the ideas of what is a good life, what is a good society. They may have deep disagreements about commonplace questions. What is the role of the family in our public life? What is the role of religion in politics? And so on and so forth. These deep disagreements are not disagreements that we can resolve easily by political majorities, because societies may be fractured enough that they may not be held together if we allow these deep disagreements to erupt every now and then. Constitutions serve this important second purpose, in that they either resolve these deep disagreements in some particular way, or they defer these deep disagreements. They confer the power on this or that institution, let's say the court, or let's say parliament, to resolve these disagreements. The third reason that democratic societies may need a constitution is that there are historical episodes where a political majority is formed, but the majorities might make some very poor decisions about how this political society should be governed. In constitutional history and constitutional theory, the most common example that is canvassed is the problem of the Weimar Republic in the late 1930s in Germany. The Weimar Republic was a democracy, but it still allowed the consolidation of majority power and the rise of the Third Reich. And with Hitler, we see a range of disastrous consequences, both for Germany and for much of Europe, but one that has emerged through the democratic process. So it's often commonly agreed, that even if we had a robust democracy, democracies are susceptible to the problem that temporary majorities might take decisions that might have disastrous and poor consequences for that political society. These three reasons of coordination, the resolution of the disagreements, and the problem that of temporary majorities being misleading the nation, are problems across all societies and are commonly understood as good reasons why even a democratic society needs a constitution. Now, it's not clear that in the emergence of the Indian Constitution that one of these three reasons dominates, but it's fair to conclude that all of these three reasons contribute to the constant assertion in the freedom movement in the early part of the 20th century, calling for a constitutional democracy. The second question that we brought up and addressed in the last session is what is a constitution? How is it different from ordinary law? And the answer to this question and a clarification that is necessary is that we understand that constitutions are placed at the uppermost point in the hierarchy of laws. All laws are ordered and the constitution sits at the very top. What does that mean when we assert that the constitution is supreme law? It means, at the very least, that all other laws made by the legislature and made by the executive branch must comply with the constitution in order to be valid law. So the validity of all other ordinary laws is tested on constitutional grounds. Now you might say, what constitutional grounds? And we have the opportunity to go into these questions, these issues in some more detail later in this course. It's important, even at this early stage, that we recognize that constitutions are a touchstone for legal validity. The failure of laws to satisfy the constitutional standard would mean that the law is not law at all. So this was the second question that we raised in week 1, and we answered and explored in this way. The position of the constitution in the hierarchy of laws often sparks the curious student to ask, what does the constitution have to comply with? Does the constitution have to be valid? Can there be an invalid constitution? This is an interesting and important puzzle in political theory and political philosophy. It's not a puzzle that I can try and resolve at any length today. Let me just say this, that the problem of constitutional validity is more likely to be a political problem rather than a legal problem. So we may not be able to develop a test of legal validity for the constitution, but maybe we can have some political norms on the basis of which we judge whether a constitution is a good constitution or a bad constitution. The third question that we addressed in week 1 is to ask whether the constitution is a political or a legal document. And the answer to that question, as we explored last week, is that it is both. They are rules of law enforceable by a court, as well as being a charter of political aspirations. They tell us, the Constitution tells us, about the kind of society we want to be. What kind of political society do we want to be? The preamble, and you discussed the objectives resolution, which was then crystallized in some form in the preamble to the Constitution of India 1950. The preamble says many things about the kind of constitution and the kind of political society we are. It tells us that we are sovereign, socialist, secular, democratic and a republic. And I'm only talking about the first phrase of the first passage of the paragraph of the preamble and highlighting some of the big values. There are many other values in the preamble. But please remember that when we say it's a charter of political aspirations, these are all choices that our constitution framers made. We need not have been sovereign. We could have been a dominion under the British Crown. We need not have been socialist. We could have been, we may have adopted a libertarian political model. We need not have been secular. We could have been a theocratic state. We need not have been democratic. We could have chosen a form of representation that was indirect and not popular. And we need not have been a republic. We could have remained a subsidiary state of the British Empire. All of these choices were choices made through the process of the freedom movement, which are then crystallized and contained in the Constitution. So the Constitution as a document performs both these functions. It tells us about the kind of political society we are trying to create, while simultaneously creating some legal rules that are fully enforceable by a court of law. The fourth question that we asked and we partially answered in week 1 is whether a constitution is specific to a society or if it is for all societies for all time. In other words, this fourth question it asks if the constitution is universal in character or it's particular to a particular society and location. And we answered this question in this way. We concluded that the Constitution is historically and socially specific. It must respond, a successful Constitution must respond to the social and political challenges of the time. So for India in the 1950s, you have a poor, low literacy, underdeveloped economic society with sharp social cleavages on the basis of religion and caste and gender, among others, and with a significant rural population. This kind of social context informs the kind of constitution that we have written for ourselves. If the Constitution did otherwise and just spoke in terms of abstract principles, which were unconnected to the social context of our time, the Constitution would not really have roots in that political society. While we emphasize that good constitutions are rooted in the political and social circumstances in which they are created, we must remember that a good constitution is not one that lasts for a few months or a few years or a few decades. We generally ascribe to constitutions the quality of durability, and the durability that we seek to achieve is across centuries. So the US Constitution, which has survived 2 centuries and more, is the kind of example that we look to as being a successful constitution. But if a constitution has to survive across this period of historical time, how can that constitution be very specific? Right? It has to speak in terms of general principles, create institutions that can survive this period of historical time, while at the same time responding to the political and social problems of any particular society. This question of specificity also begs us to ask, so are all constitutions the same? Should we borrow from other constitutions at all? Should we know that the US Constitution is often showed up as a model of a good constitution that has survived over time and helped create a prosperous society. So does that mean that we just, take the US Constitution and adopt it. Why do we need to write another Constitution? The problem and the tension between a universal approach to creating a Constitution and the specificity of the social context means that we have to tread cautiously while we look to borrow constitutional principles. Constitutional principles and institutional design, we must be open and learn from others, but be clear that a one-size-fits-all strategy is likely to end in tragedy rather than in success. So these 4 questions were the questions of week 1. My colleague from the National Law School, Professor Aparna Chandra, took you through these questions in a particular way and explored them at length. I hope that my summary addresses some of the questions and issues she raised and pushes you to think a little beyond what might have been covered in week 1. You've also had an assignment where you've had the opportunity to test your understanding of that initial material. In the weeks to come, we will put together and share a more well-rounded body of materials that can help all of you study and prepare for this course. But till then, in our introductory weeks, we will go light on the materials so that we give you the opportunity to genuinely, openly think about these important questions and engage with the constitutional experiment that India represents. The outline for week 2 is what I'm going to move to next. In week 2, once again, I'm looking to ask and respond to 4 discrete questions. The first question is, how should a society make a constitution? Please remember that the word should is very important, because what I want to unpack is what are the models, what are the broad ideas that can inform a constitution making project. Imagine for a moment you were invited to a newly formed political republic, let's say somewhere in the Pacific Islands, which wants to adopt a new constitution. What kind of method would you advocate for such a society to make its new constitution? The second question is to address a question about political history. This is something that you are familiar with from your civics books and in school, but let's try and build on what we already know to sketch out a wider sense of this constitutional history. How did India make the Constitution of India 1950? We can ask this question as a question across a large swathe of historical time. I will be a little more specific and look closely at the period leading up to the Constitution between 1947 and 1950. Now that we have given ourselves a Constitution in 1950, we must ask, is that all? Constitutions once made are there forever? Why should so many of you born in the 21st century be bound by a constitution that was made in the middle of the 20th century? So a partial answer to that question is to acknowledge that constitutions change. How do constitutions change? Do they just, should we just replace a constitution every 25 years or some such thing? Or is there a more organic manner in which constitutional change can be managed and carried out? The fourth question is, can Parliament amend and replace the Constitution? Many of you might have read last week that a pontiff, Sri Keshavananda, passed away, and the newspapers reported that this pontiff was the key petitioner in a case called Keshavananda Bharati versus State of Kerala. And this case went into the question of the parliamentary power to amend and replace the Constitution at length. And while I will not, in the second week of this course, drag you through detailed legal arguments, it's hardly the point of this course, the case raises questions that we want to be conscious of and particularly attentive to for the rest of in response to this question. So those are the 4 questions that we will address in week 2, and I will do this through short videos on each of the questions, or exploring the question at some greater depth. So let me begin with the first of these questions. How should a society make a constitution? So the key puzzle that we are confronted with when we ask how should a society make a constitution is that we understand that constitution making is supposed to sit above the fray of ordinary politics. If you want to make the supreme rules of the game, can you be a participant in the game? For example, in an ordinary sport, in cricket or in football, you might have an umpire. The umpire is not playing the game. You might have a referee in football. The referee is not playing the game. And the rules of the game are codified and put together by authorities who do not have any stake in the outcome of the game. But when we think about how a constitution should be made, our general intuition is that constitution should be made by the people that the constitution might govern. But does this not raise problems of neutrality? Why should I know exactly where I'm going to be once this constitution is made. Hence, I want to design a constitution that best serves my own interests. How do we create this neutral space from which a constitution may emerge? Ultimately, if a constitution is going to do all the things we spoke about, solve coordination problems, resolve deep disagreements, and also deal with problems that political majorities may get swayed, then it's supremely important that the constitution has the allegiance of the people and is not seen as a partial document created by one party or another. The answer to this question, how do we create a neutral space for the making of a constitution, has been answered in several ways. And let's explore a few of these and recognize where India might fit within these models. The first approach is to think that making a constitution is ultimately an exercise in legal expertise, maybe legal and political science expertise. There are people in the world who have been highly educated in the fields of law or political science or related cognate fields that might have a significant bearing on constitutional design. These are people who arguably understand their society well, understand how to design and write a constitution. And these people might be the people who we give the constitution writing process to. This has been attempted in some jurisdictions and was proposed for India. Sri Lanka is one of those jurisdictions, a neighbor to the south, where a constitution was created on the basis of an expert committee. Now, the Sri Lankan experience with an expert committee drafting the constitution has not been the best experience for us to learn from. Sri Lankan constitutional longevity, durability, and battles around the constitution continue until today. If you've been following the newspaper over the last week, the constitution has been amended once again to confer wide and sweeping powers to the president. So Sri Lanka's constitutional history is a sagely caution against relying too much on expert committee based constitution making. Option number 2 is to allow constitution making to be conferred, the power of constitution making to be conferred on a representative body. This representative body can be the ordinary legislative assembly, in India's case Parliament, or a special representative assembly like the Constituent Assembly. So let's think through these questions with some care and precision. Why should constitution making be done by a representative body at all? Ultimately, we might all agree that the wisdom and the foresight as to what constitutional design may work in the society may be widely spread. In any event, we want the widest swathes of the population to accept the constitution and see it as a legitimate rules of the game. So for both these reasons, it may be good for us to have a widely representative body that can command the affection of the people while making the constitution. Now, Parliament is precisely that kind of body, elected on universal adult suffrage, at least post 1950, and allowing for the widest range of people to select their representatives. And these representatives might act in the best interest of their constituents, and hence we might get a good constitution. But there is a problem with relying on an ordinary legislative assembly. We all know that political parties and the nature of electoral hustings means that parties will represent marginal interests. It is not always clear that representatives in a legislative assembly elected on a party basis may rise above their party affiliations and their particular community or religion, class, backgrounds, and think about a constitutional project in this forward-looking, multiple centuries kind of way. So, for that reason, for the reason that parliaments, ordinary legislative assemblies, seem to be too political in their orientation, that scholars have often argued that they may not be best suited for designing a constitution. What options do we have? The option we have is to try and create a representative assembly, but one that is uniquely representative of the widest range of people who may not even be, they might be small minorities that may not have the ability to elect a representative even in a majority vote system. Even those communities may be represented in this special representative assembly. This is certainly the model that Indian constitution makers sought to adopt, and this model is the model that the Indian Constituent Assembly takes forward. There are arguably at least two other significant ways in which a society may make a constitution. The first is that it can be drafted by some entity, but then it might be put to a popular vote. Now, please remember that what the formidable challenges of a popular vote, a referendum on the constitution might be. At the best of times in our political lives, for the electorate, the popular electorate, to understand the constitutional text in its range and complexity is challenging. And for them to then understand and endorse an entire constitutional text may seem particularly daunting and may not be both politically or, for that matter, cognitively a feasible path. But maybe then we simplify the questions. If we simplify the questions and then just make it a simple yes-no vote, for example, should India be a sovereign country? We might ask as a referendum question. And then just allow the people to vote in an up and down way, either yes or no. This is an appealing approach to the question of constitutional choice, and there are many who argue that this is the only legitimate way in which constitution making can make progress. However, this model, as for those of you who have followed the recent debates on Brexit, it makes clear that even a simplified question that is posed to the wider population may yield a very close result, and one that may drive the nation in directions that may not, in historical retrospect, be seen to be either wise or feasible. Now, the jury is still out on whether the Brexit referendum and the choice of the British people is ultimately in their overall best interests. But you can see in the intermediate stages, while the legalities of Brexit are being negotiated, that this was no easy choice to make or to deliver. And so there are reasons overall to be skeptical about a popular referendum route to constitution making. I'm going to close with the first question for week 2 by paying attention to South Africa's approach while it emerged from decades of apartheid. The South African approach was that while it was clear that white minority rule was no longer sustainable, the transition to a democratic nation was one that had to be negotiated in what is called the Kempton Park negotiations. For those of you who are interested in the South African story, these are all reasonably well documented and available on the internet. So you have political negotiations between the representatives of the black majority and the political representatives of the white minority. But that was not what concluded it. After the constitution was drafted, there was a concerted way in which the Constitutional Court of South Africa had to review and confirm that the constitution that had been written was one that stuck to the negotiations, the negotiated result between the white minority and the black majority. This too is a structured and tiered way in which a constitution can be made, and one that gives the judiciary a place in constitution making. This occurred in the 1990s. There was no anticipation or thought that this could be done at an earlier time, and the Indian Constitution certainly did not anticipate such a mode. So let me conclude this discussion that whenever we think about how a constitution should be made, we have an array of options to choose from. We must remember that the end result must satisfy the core functions, the core purposes of a constitution. It must be one that a society can embrace and adhere to for long periods of time, and it's that kind of constitution that must emerge from whatever process and design method that we choose. I mentioned earlier that India chose a special representative assembly, namely the Constituent Assembly, as the way to go forward. And in my next lecture, I will focus my attention on how the Constituent Assembly was set up, who was in it, what did it discuss, and some key ideas that emerge from this process. Thank you for your time and attention, and look forward to engaging with the second lecture of week 2.